World Intellectual Property World Intellectual Property Organization, that is called WIPO, which provides a unified procedure for filing the patent applications in several countries. So it is a very useful procedure, and which gives like a benefit not only in India, rather to all the countries as well. Like in parts of India, if you want to explain there, then India is also being a contracting party of this treaty since 1998, like which allows the inventor to use this PCT system for securing the international protection. So in short, like if we trying to say that what is the basic advantage of this PCT system, that is the patent cooperation treaty system, which is enable the every inventor, like by filing a single application is sufficient for getting protection in the multiple jurisdiction. So multiple jurisdiction in the multiple countries at the same point of time. So it is the most biggest advantage of it is that it is like it is less time consuming. So the like time as with the time advancement, it the every applicant get up to within 30 to 31 months that they can decide on which countries they are want to filing. So within that time framework itself, they can identify and they can file a single application. And along with the same application only, whoever the countries are the signatory or like member of the or signing the patent cooperation treaty itself, so automatically if you get a protection from one place, then it will automatically giving you the same priority to the other nations as well. So this is the benefit of PCT like application filing for a patent for protecting the invention. So the another most advantage we can say that it is cost efficient, like cost friendly. So it is very efficient for every like inventor, that by filing one simple application, they can basically defers the transaction and the national filing fees, whatever the requirement will be there, like which country filing you are there, like filing based on that the jurisdiction, and mostly that the covering countries, so the respective fees you need to pay, and based on that whatever the stages, the later stages will come, based on that you need to go with the procedure. So it is as less costly as like the other, like it will take more expense if you are filing separately a single application to every country for the specific protection or from the specific jurisdictions. Okay. So the another most important like pros we can say that this PCT like patent cooperation treaty like it improved the quality of the applications. Like they are asking about the like the ISRs and also the IPR, that which one like help for the accessing the patentability before entering the cost like costly national phases, like whatever the stages will be there accordingly. And the another most advantage we can say that which gives a wider protection. Okay, it's give a wider protection, like which is covers almost 150 contracting states. Like these 150 contracting states will be the signatory of this treaty. So it will giving naturally a wider protection. So on the other hand, if we say that what are the strategies we need to follow by this application for this PCT filing are, so as we know that PCT route is very economical. So only if one is seeking the patent protection in a number of countries, right? So therefore, deciding upon filing a route like which is very crucial. So it is also extremely useful and cost effective if the applicant is not secure about the commercial potential of the invention at the initial stage, and if he needs time to search for an interested license or the venture capitalist who could take his invention for further the development and exploitations. So in such case, that ISR would also gives an idea to the to giving an idea to the applicant about the shape, like where the invention is placed, and with respect to the patent, from where which can be taken by the competitors. So depending upon the nature of the invention and its advantages, the applicant can decide as to how to proceed further. And we can say that with due to this huge investment involved in this every the branch of the research and development, it become the crucial for applicant to take a decision for securing the protection for his technology, in relevant any relevant markets, whoever will be practicing or taking the invention based on that particular market. And depending upon the that particular IP budget, whatever is available within him or within his jurisdiction or within his sphere of the invention, that is. So all these connections are considering together while we are formulating a patent strategy. So for this purpose, some strategies which can be adopted, like at least we can say there will be a simplest in a way, there will be the three major strategy can be followed through this patent cooperation treaty is giving the direction for this. In these three stages, anybody can be filing the PCT application. So in the very beginning, first strategy is stating that, like, one of the option, like an applicant would have, that they would be to file a provisional specification. Like provisional specification here means the in detail, like whatever if they are getting a invention regarding some technical areas, then including that the technicalities of that particular invention, step to step, everything they need to be clear clarify in the specific application. So every specific details need to be mentioned in the application. After that, those application they directly taking to that specification at the national patent office, which is followed by the application under the PCT. Then this option gives to all the applicant more time, up to 1 year, or to find to finding the tuning of the particular documents, like what are else are also required or not, how they can be improved. Okay, that about to drafting that particular application, or maybe they are regarding that innovation only, already they are being working on, so they can file that application. Then later on they will till upon the disclosure they can continue. So as the depending upon the as the case may be. Okay, so it can be followed by filing of a complete specification. And PCT filing, they have to submit within 12 months from the date of the provincial filing to securing the priority. So based upon the priority, they need to be submit anyhow that within the 12 months that PCT application in case of strategy 1. Okay, so on the other hand, if we talked about the strategy 2 that they are offering in this PCT system is, in case a complete specification was filed in the first instance, okay, and one file an international patent application under PCT with 1 year from the date of the filing, the to the complete the application. Or on the third strategy, we can say there are the situations where the subject matter of a patent application is not patentable in India. So, in such cases, one can obtain a foreign filing permission from the Indian Patent Office, and that file, an international patent application directly accompanied with the a foreign filing permission only. So, if like this strategy, if we can explaining by steps, two step, so by that will be like a step by step chart. We can say that the strategy one talking about the provincial application, which need to file first at to the national patent office only. Okay, and the second file of the patent application, which need to like with the complete specification, they need to be filed before the national patent office. Okay, or on the third hand, they have an option that this PCT application they can file with prior foreign filing. Okay, prior the for like foreign filing, they need to take the permission from the Indian patent office. So in this three strategy, they can be these are the options are available to them to filing the PCT application. So same in case of strategy 1 and strategy 2, that within the 12 months the complete specification to be filed, they need to be filed before the national patent office. Or in case of strategy 2, within 12 months from the priority date only, which need to be like the patent application which need to be filed before the this PCT application needs to be filed before the national patent office. Okay, and then the third strategy itself that talked about the PCT application, like the prior, like which is prior foreign filing permission from Indian Patent Office, they need to be submitted at the like designated receiving office, like which may be the National Patent Office or maybe the International Bureau. Okay, so when this all the records have been got received by this office, then they will send this application to the specific purposes. Like for the specific purposes, first they will send it to the record of the copy, for a record of like record of the copy to the International Bureau, then sending another copy to search copy to the International Search Authority, and after that also they will send it the one more copy to the like one head copy to the receiving office. Okay, and all this, when this all these three copies has been received, then within the like before expiring of the 14 months, it will be again send it to the like the compilation of all the reports, and along with the application of PCT, it will be send it to the International Bureau, send it to the one copy of those the entire attached file to the applicant, and one full copy of the report along with the application with the International Search Authority, and one more is the receiving office. Okay, so in that way, that within 3 months from the receipt of the search copy, or like take 9 months from the priority date, like whichever the time limit like expires, like whichever the time limits will be expires later, based on that, that ISA established the international search report. Okay, so within these 2 months from the establishment of ISR, this international search report, the info, the formal comments or the like amendment or claim or the priority claim, whatever are filed at the International Bureau of receiving the office, based on that, the international search report of the like international sorry, the international search report with the informal comments, like if it is there then only, if it is not there then it's fine. So they need to be somehow communicated to again the applicant. After that, they need to communicate to the International Bureau, and also they need to be communicate to the receiving office. Clear? So at completion of the 17 and a half months, then this application has an the like within this 17.5 months, those applicants having an option in this phase. So if any applicants has like they wants to just withdraw their application or anything, if they having intended to, so they has an option to stop the publication. Okay, So by the reason for by any like anybody any applicant, if by withdrawing the entire application, or maybe the reason for by withdrawing the earliest priority claim, or maybe by withdrawing the withdrawal of all the designation except the like India, if it is there, then only the applicant has an option to stop the publication. Okay, but if it is not there within that period, if no like withdrawal or something is being there, then the same application with completion of 18 months itself in total from the beginning, then that application will be published, like the published in the official website of their journal. So at completion of the 22 months in total, they can demand for the international preliminary examination. Okay, so after completion of that preliminary examination at almost covering the 28 months, they can the authority of the international bureau will be issued the IPR like within the 13th of the month, the like since the filing of the date. So in that case, the national phase, they will granting the national patent, the application will be granting from the patent from the national patent office. Okay, so if we summarized the timeline framework, that how much time it will take for the PCT, then we can easily state it that like in the first month, it will be like to the national, regional or PCT filing for the priority date wise. Then next 12 months it will take to PCT filing in case filing in a national patent office. Then next 16 months will took for ISR and patentability option of ISA regarding. Then later on, within the 2 months from ISR and filing to claim like amendments, then within 18 months, the international publication has been done. If there will be no objection or nothing will be there, then within the 20th month, the first like the chapter for this basically dealt with the national phase entry in a new office, into the few offices. So then on the 13th month, either the firstly commencement of the national phase entry in the most office, or otherwise the communication to the IPR to the designated office in any way, this can be done within 13 months time frame. So in the part 2, if we say the time frame will be taking this application to completion. Firstly, that same within that 18 months, the international publication has been done. So in 19 months, the early filing to demand, like whoever will be filed for that request, then based on that, it will be the demand will be based on that demand only, it will be acceptable. So next 22 months, like as per the filing of the demand of the amendments and or the arguments, like which arguments has been raised by, if there will be any complaint or obligation will be arises, if anything like objection has been arises, then based on that only like whoever getting the responses on behalf of their, the judgment will be to say on that basis they will demand the arguments or the amendments for this changes, like whatever the issues has been raised. So in the next 28 months, they then only the establishment of IPRs will be there. So next 30 months to 30th 30 month 30th number months, the commencement of national phase entry and also the elected officers will be communicated completely. So in case of PCT, it is the first filing of ISA established the ISR and written opinion before expiry of the 9 months from the date of priority. And the second thing we need to note it there, that the respect of a few states, the time limit of 30 months to enter the national phase will available. Like however only apply if those states have been elected in a demand file like before the expiry of the 19 months from the priority date, like for an updated list of a state concerned, then they can see for the PCTs in internet site. Okay, And the third most important thing we need to note it here, that a demand for the international preliminary examination may be filed at any time, like prior to the expiration of the 3 months from the date of the transmissional, or of the like from the ISR, or to the WO, or 22 months from the priority date, like whichever the time limit will expire later, based on that they can file. Or like in a simplest way, if we try to say that how this like in a simplest way, if you want to say that how that like with an example, if we want to say that in India, how an Indian pharmaceutical patent has been provided, then we can see an example. We can take an example like Nactobar's case will be available, where that they can like buyer entered the national like Indian national phase and obtain a patent license, international patent license, accordingly in the year of 2012. Okay. And if we say a quick uh, aspects about the international filing of the any patent application, or any the phase for the PCT filing, there will be the slight difference, difference that is like in a time framework. Okay, like in case of direct international filing, it must be the applicant need to file in each country within 12 months of the first priority of the application. But in case of PCT filing, like patent cooperation treaty filing, within such place of application, they can file it within 30 to 31 months from the priority date before the entering national phase. So in case of cost budget and all, if we say, there will be like in case of direct international filing, it the cost will be higher, upfront cost like transaction, official fees, attorney fees, each etc will be each country they need to carry. But in case of PCT filing, they will be defer major cost only until after the search report and publication only they need to pay the respective fees. And in case of flexibility, if we say that direct international filing, it will be limited, and decision on the countries must be within 12 months only. But in case of PCT filing, it will giving a greater flexibility to the applicant, who can evaluate the ISR or IP, or IP RP before the deceiving, where the like they can have an idea to deciding where to file. Or in case of examination, each country conducts its own searches and examination independently if you are filing a direct international filing. But in case of PCT, the centralized international search and the preliminary opinion give an early idea of the patentability. So, if I give you an example like of that, and in case of direct filing, an Indian investor files directly in the US and EU, European Union, within the 12 months of the Indian filing. But in case of PCT filing, an Indian inventor file a PCT application later entering the US. Or European Union, China, or Japan, or any international or national phases itself. So, direct filing based for targeted protection in only a few countries when market are already been decided. But in case of PCT filing, it will be best for invention which uncertain, the invention which are uncertain, or global markets potential. Okay, based on the global markets potential, or which offering the time and cost and flexibility. So in that way, the PCT will be very much benefited to us only. Okay. So now we are going to cover the second part of this topic, that is the patent and technology transfer. Now, this conception, if we are trying to say that basically technology is the backbone of the economic growth and innovation, right? So, like for technology to like how this technology to become the benefit for the society, it must move beyond the laboratories and the research institution to industries, and also to the markets and the and it end to the basic to like it should be end up with the users. So this process is known as the technology transfer. So patent, by granting exclusive rights to inventors, which play a crucial role in enabling and regulating this transfer. So in simpler way, if we try to say that what is the meaning of the technology transfer, so basically technology transfer refers to the process by which knowledge, innovations or inventions developed in one place, and such a in such a university or any research and development lab or any corporate research center, so which are shared, the licensed or transferred to another entity. Like it, this entity might be the industry or enterprises. So for it will be sharing for the commercialization purposes and practical uses only. So it will be the main crucial intention or aim will be behind of it. So like the if we want to explain that what are the forms to transfer, like how this technology can be transferred, then we can say that it will be transferred through there will be like in a horizontal manner, vertical manner, or maybe the cross border transfer manner. Okay, so in case of horizontal transfer, it will be done between the firm in the same industry or the country, or the technology can be transferred into the vertical way from research institution to universities to industries. Okay, and if we say that the how it will be transferred to like a cross boundary cross bounded transfer, then the international movement of technology between the nation, like whenever there will be the two or more nation will be involved, then with the cross border transaction, by that way the technology can be transferred. So later on, if we want to discuss about that, what are the mechanisms are available for this patent-based technology transfer, then we can see as per our Patent Act has been giving the opportunity, like the options, like through the licensing. Okay, so the through the licensing agreements, any inventor wants to transmit their invention technology to the other nations as well, or to any other ways, like maybe horizontal, vertical, or cross border, in any ways. Okay, so in this licensing agreement, firstly there will be, they can make three types of agreement they can be done. Like first, exclusive license. That exclusive license is only like one license can be used by the patented invention, which is offered by the patent office towards to only solely to the inventor only. Okay, and he can only enjoy, the inventor only can enjoy, that is the exclusive license. On the other hand, the second in the second way, that non-exclusive license agreement can be made, so where the multiple licenses can use the technology simultaneously. Or there will be thirdly we can say that the compulsory license, through the mode of compulsory license agreement, which grant by the government in public interest. Only on the public interest the government has an authority to providing the compulsory license. So example, like under the Indian Patent Act, section 84 is clearly stating about the conditions, how what need to like fulfilled, and all everything detail will be over there. Okay, and the later on the another mechanism by patent based technology transfer is through the assignment. So transfer to like transferring of all, like either will be the full ownership of the patent, or maybe the particular period of time, the patent to another entity. Okay, this patent will be transferred to the another entity in exchange for the consideration. Now this consideration may be in the form of royalty or maybe in the form of any services or the remuneration forms. Okay, it can be transferred, or it can be transferred in the mode of joint venture or collaboration. Like this joint venture or collaboration can be done with the universities and the companies, like who are jointly develop the technologies and share the same patent rights. Or it can be transfer through the mode of technology, like the technology transfer office. Through that way, that where the university and the research and development institute, like they will establish the one TTO office, that is called transfer technology transfer office, to manage the patent, like managing the particular patent and licensing and the partnership. So this office can be regulated to communicate, like every like if you see the biggest research institutes we having in India, we can see they having, after the completion of their particular research, they will be getting an aid to guidance to how to file that particular patent application, to after that how to commercialize it. They giving a guideline, like as a guidance to that regarding, or we can say the helping hand who will be guiding to the inventor. Little like new inventor will getting the guidance from there itself. So through these offices also we can design, or this will be like helpful for the those students in case of who are being working for the research and developments. So another way, the if we say that what are the challenges we are being facing regarding the patent based technology transfer, that it is always in high in cost. So licensing fees and also the royalty rates, it can be like prohibitive. So the another challenges we can see, that the valuation in the like difficulties, like difficulties in to determining the market value of a patent, which is become very complex. Another way, like the another like cons we can say that here, that the regulatory issues, like variations in patent laws across the jurisdictions, and what are the types and specifications are available to which jurisdiction of the countries and all. Based on that, different country is having their own specific rules, laws and procedures, right? So these regulatory issues are also being facing, and it is also been very difficult sometime to transferring the patented based technology transfer. Another way, the another most important we can say the challenge we are facing regarding to like to accessibility and monopoly. Like in that case, balancing the patent protection with societal need is very much essential. Very much essential. Like for example, if we can say that one particular country has getting a patent on some life saving drug. Okay, now it cannot be like if that particular country is getting the patent only, and later on they are not producing or using the patent for the benefit of the common people at large. Okay, or neither they are producing the medicine, neither they are selling. That in such cases, then the government can taking the step for to prohibiting them or prohibiting to the monopoly in the market. So our regular like laws has been prohibiting and giving an option for the compulsory licensing, and also for to granting only for protection for the public at large. So it is being essential, this balancing the patent protection with the social need is very much essential, specifically in the domain of pharmaceutical industries, and for the medicinal purposes. So apart from that, we can see the another most important challenges we are seeing, that is the lack of awareness. Okay, so lack of awareness. Like in developing countries, inventors often lack of commercialization because they don't know how to do commercialize their patented like innovation. Okay, because of that, sometimes they are being unable to hold their particular innovation for a longer period of time. So So if we give an example in the Indian context, we can see there are the multiple institutions who are involved to regulating for this patent transfer, helping to the patent transfer technology. So they like we having specifically the bodies like statutory bodies like CSIR, DRDO, ICAR, then ISRO, okay, then IITs who are actively engaged in patenting and technology transfer. On the other hand, we can say through that India has obtained adopting some kind of like it's a quite a bit of US style of laws which allowing the universities to own the commercialize the innovation funded by the public money. And if we say the example out of it, then CSR's technology transfer model, which has licensed several pharmaceutical patents to the Indian pharma companies. Then the one more landmark case over there, if you go and referencing that NACTO versus Bayer in 2012, where the compulsory license granting for the sorafenib, tosalite, that anti-drug one like which one drug is there which is called like using for the anti-drug cancer drug, to this Lacto Pharma has been owned, who is ensuring this technology transfer at very affordable price. Or if we say that in international perspective, so there will be the TRIPS agreement during the time of 1995, which giving some guidelines or step by step provisions regarding to harmonizing the patent laws globally and influence the technology transfer obligation that every country are bound to transfer their advanced technology to the other less developed countries or maybe as per the needy countries for time to time. And in another way we can say that the international perspective that important area are through the Doha, like the Doha declaration. Through the Doha declaration in 2001, which affirmed that the trips should not prevent any member for protecting the public health. So at that cost they are have to allow it all the countries and to restricting the conception of monopoly in the whole world. Okay. And after that, the patent, like another most important way that patent tools and cross licensing, which is in common in high tech sectors like telecom and pharmaceuticals. So that is the international perspective we are seeing regarding the patent technology transfers areas. So in a simpler way we can say that this patent and the technology transfer are the two sides of the invention ecosystem. So while the patent create the incentives and exclusivity, then technology transfer ensure that the invention reach toward the society and industries. So for countries like India, who is striking a balance between protecting the inventors and ensuring the affordable access, specifically in pharmaceuticals areas, agricultural fields or agricultural sites, or in the clean technologies. So it is very much vital. For effective patent licensing policing, the stronger university industry collaboration and the international cooperation are in very much needed in the future. Then only we can successfully complete the technology, invented technology properly we can transfer from one jurisdiction to the another jurisdiction. Okay. So the third topic we are going to discuss here today is covering the areas of that the patent regime regarding the patent and Indian Biodiversity Act. So now, patent, you all are aware of it. I hopefully defined previous classes. So now we need to get acknowledged with the another IP that is called the biodiversity. So in India, this biodiversity conception has been covered under the Biodiversity Act 2002. So in India, is like India is one of the world's most mega diverse countries, which is rich in biological resources and also the our traditional knowledges. Okay, so like various instances of the biopiracy cases where the foreign companies and the researcher obtain the patent over the Indian biological resources or the traditional knowledges. For example, we can say that regarding the traditional knowledge regarding the benefits or usefulness of the in medicinal herbs like neem, turmeric, basmati, these all are lead to the enactment of this for the protection of this our traditional knowledges. Okay, or we can say our treasures. We need to enact this biological diversity laws. So that's why this Biological Diversity Act 2002 has been enacted. And through this enactment only, there will be one board has been established. That is Biological Diversity Authority will be established. So the Convention on Biological Diversity in internationally, the Convention on Biological Diversity was ratified by 159 member countries in the year of 1992. And the main objective of these conventions are aimed at convention of the biological diversity and sustainable use of the bioresources, which are equitable sharing of the benefit arising from uses of these resources. So the sustainable use, as per the definition of the convention, specified that the use of the bioresources should be at a rate that may not lead to the decline of biodiversity. So CBD uphold the right of the several nations who will design their own environmental policies and also means to use and exploit their bioresources and take a necessary steps to ensure that the environments of the other international jurisdictions are not adversely affected. So the this Biodiversity Act of India and Biodiversity Act of India 2002, which primarily aim to covers the biological diversity safety and which is ensure sustainable use of biological resources, or we the it's also primarily aiming to protecting or guarantee fair and equitable sharing of the benefits arising out of this arising out of from using their resources or uses. So this law has significantly interaction with the Patent Act 1970, specifically in regulating the patents involving the biological materials from India. So the most important highlighting provisions of these acts are, if you want to highlight it, that there will be one regulatory bodies, right? So that there will be the regulatory bodies such as National Biodiversity Authority, which regulates the aspects to biological resources for the foreigners and also the overseas regarding the benefit sharing. On the other hand, we having the State Biodiversity Board, okay, who is monitoring the local use and advise the state governments, and we having the biodiversity management committees. Okay, so at local level, these BMCs, that Biological Management Committee, who will be maintaining the people's biodiversity registers. First of all, they need to be registered. Okay. So this board, PBRS, that is for People's Biodiversity Registered Office, need to be originated, or every in the local level body, it will be established over there through this guideline of this act. So another major provision of this act is regarding the access to the biological resources. So how they need to be accessed and all the procedures are being mentioned under section 3 to 5 of this Biological Diversity Act clearly, which states that the foreign individuals or the companies, whoever is required, they need to be take first priorly the National Biodiversity Authority's approval before accessing any Indian biological resources. And also in case of Indian companies or Indian citizens, they need to take permission for transferring research result to the foreigners. Like before they are transferring the result, they need to take the permission from the Indian. Okay. So the other major provisions, important provisions of this act is highlighted here, that regarding the benefit, the provisions are saying under section 23 to 21 to 23, if you look into the provision, they are giving the guideline or the direction to the users that how the users must ensure fair and equitable share of the benefit with local communities as well. Okay. And the modes also, like modes like join the IPR through by joining the IPR ownership, or maybe the technology transfer, or maybe by monetary benefit sharing, or by the venture capital support. In any way they can sharing the benefit. So on the other hand, we can see the important like IPR related provisions we having under this provision, which is giving the prioritize importance of this particular Biodiversity Act is like prior approval of NDA is mandatory before applying for any IPR also. Like in case of patent, plant varieties, and etc., they need to be get permission from this NDA only. And in India or abroad, based on the biological resources, they need to be obtained from permission in India only. After that, the Patent Act 1970 was amended, so like section 10, 25, and 64, regarding to ensuring the disclosure of such sources also, and geographical origin of that biological material in the patent application. Otherwise, it will be become a threat towards those treasuring our biodiversity resources. So on the other hand, if we say the what is the major relationship between the Patent Act and the Biological Diversity Act is that our Patent Act 1970, which requires to disclosure of the source origin of the biological material used in an invention. Okay. And the another way that the opposition grounds like pre-grant, post-grant, like it will be done like if biological resources were used without the NDA's approval, the patent may be challenged. Or in the by way of like same provisions are available like revocation, regarding that a patent may be revoked if it is contain the provisions of the like contravention of any provisions regarding the biodiversity authorities. Uh, or in combining if we can say that both the acts, the Patent Act and the Biodiversity Act, works together to prevent the biopiracy and ensure the ABS compliances only. Okay. So in if we see the major landmark cases in regarding that where the patent and the Indian Biodiversity Act has been seized, or we can see the protection or the major landmark judgment will be there. Certain like a case you can see and find that turmeric case, which is decided by USPTO in the during the time of 1995, as per the patent granted, like US patent granted an university to Mississippi for turmeric's owned healing the properties, right? So it will be revoked after CSI's approval, like proved prior tradition use in India. So highlighting the need for protecting the traditional knowledge. Apart from that, if you see the NEEM case where EPO 1995 to 2000, during that era, they can highlight it the regarding that European patent granted to WR Grace for neem-based fungicides. So, which is again revoked after NGO and the Indian scientists challenged it used to the prior act, which is being already being registered in Indian domain. So in that same way, there are the various others also you can see. Now if we want to focus about that, what are the emerging issues and challenges we are being facing, those are being will be regarding like overlapping of the laws regarding the biodiversity acts and the patent act, which is like the complexity due to the interaction between these two acts. It will overlap, like sometimes the provisions are become overlaps with one rules to the another one. So another challenge we are seeing that the traditional knowledge which often undocumented, so it being difficult to prove as a prior art. On the other hand, the enforcement problems are also we are being facing regarding the limited awareness among the local communities about the benefit, rights. So on the other hand, the global biopiracy is also major issue we have been facing. Once the patent are granted in abroad, the revocation requires a huge resources and the international cooperation. So balancing between the innovation and the conservation need to encourage biotech research while the protecting the biodiversity is very much necessary nowadays. So, if we like to say that what are the latest developments has been done, that is the traditional knowledge regarding the digital library. Okay, by recent developments, like we have a treasury, by establishing of traditional knowledge digital library, which is established by the CSIR to documented the traditional knowledge, like traditional knowledge, for example, regarding Ayurveda, then Siddha, then Unani, then Yoga. These all are the conception is really there. These all are already being registered under our National Knowledge Digital Library, which will be treated as a prior art, as an evidence. So, and which is prevent to misuse in the patent claims. Then WIPO negotiations are also being there for the recent current developments. India is actively participating in WIPO's intergovernmental committees on genetic resources and traditional knowledges nowadays. And if we can highlight that in 2021 era, the amendment bill for the Biological Diversity Act, which aim to simplify only the process for this, I use participants in the local communities while still safeguarding the resources only. So, in summarized, in summary, we can say that the Indian Biodiversity Act, when read the Patent Act 1970, provide a robust framework to prevent the biopiracy and ensuring the equitable benefit sharing and protect the India's vast traditional knowledge and biodiversity. So, however, challenges remain in the global enforcement, regarding the awareness among the stakeholders and also harmonization with the international patent laws. Though it's going forward, but still strengthening like international mechanisms like NBA, then TKDL, and the local BMCs will be crucial to safeguard the India's biological wealth while fostering the innovations and various new technological inventions, etc. and etc. So if we can see that the latest development what are being happening, apart from that, there will be the patent landscape. We can see that in the one of the major developments is growing focus on the regarding the pharmaceutical patents. So especially like specifically after landmark judgment of Novartis versus AG versus Union of India, where the Supreme Court reinforced Section 3D of the Indian Patent Act to prevent the evergreening of the patents and ensure the affordability of access to the medicines. So this reflects the broader global debate between the insensitivizing innovation and also safeguarding the public health. So similarly, the compulsory licensing provisions are also being important, as seen in the Bayer Corporation versus Nacto Pharma. In 2012, Supreme Court is highlighting that the India's use of the TRIPS like flexibilities, like TRIPS agreements provisions flexibilities or applicability to promote accessibility of the life-saving drugs and setting a precedent in balancing commercial rights with the public interest. So another emerging issues in the patentability of biotechnology and life sciences innovations, we can say, particularly concerning the genetic materials, which like genetic materials like stem cell research and plant varieties. So the interface of the Indian Biodiversity Act with the Patent Act 1970 has made it mandatory for the applicants to disclose the surround and the origin of the biological material, which aiming to prevent the biopiracy and also ensure the benefit sharing with indigenous communities. So, moreover, the rise of the artificial intelligence in the machine generated invention, which has triggered the global database on the like global databases. So whereas the AI can be recognized as an inventor. Sometimes AI can be generated some new of the contents which will be finding out from there as well. So while the jurisdictions like United States, Europe have rejected such claims, but still discussions are going on before the WIPO, World Intellectual Property Organization, regarding the reforming patent laws to addressing this gap. So by using these AI based technologies researches. So later on we can see the recent development. We are seeing that the digital in this digital age, has also been raised the concern regarding the softwares and also the business method patents, right? So in India, computer program per se are excluded under section 3K of the patent act, but when it tied to the novel technical application, such innovations may be patentable. So these countries to be a gray areas, unlike the United States, where the allies crops versus CLC Bank in 2014, the decision narrowed the scope of the software patent. So another development in focus on the green technology patents, as the government worldwide encourages the innovations in renewable energy, electric mobility and claim friendly technologies. So patent pools and collaborations licensing mechanisms are being exposed to accelerate the diffusing of such technologies while maintaining the incentive for the inventors. So these are the things we are being seeing in very large in numbers, these issues and all, or the technological advancements. So, in summary, we can say that the emerging issues in patenting is generally concerned to what is patentable, the procedure to be adopted as to ascertain what is patentable, and to deal with the issues arising from the development of new technologies. So, in this sphere of the biotechnology, medicine, internet technology, nanotechnologies, space related technologies, and also the innovation that can be done and cannot be patented in the defense and the atomic energy sectors. So as there is no world patent, so everyone has to file a patent in each and every country that he desires to have protection for his innovation, and most international organizations deserve to continue the protection of their patents. So particularly in the pharmaceutical sectors, where the cost of research and development, clinical trials and patenting itself are enormous. Okay, so therefore they resort to what to known as a evergreening of patent. So traditional knowledge is valuable, knowledgeable, and it is should be free, like open software codes and like this. So the WIPO provides an forum. WIPO provides a forum for the international policy debate and development of the legal mechanisms and practical tools concerning the protection of traditional knowledge and also the traditional culture expression, that is called the folklore. So, which is against the misappropriation and misuse and the access, like the aspect of the access to and benefit sharing for the genetic resources. So in this way, the emerging issues and patentings are very much important to know, and important informations are already being shared to you. So if you having any doubts or query, you can ask. Then we can end the session here. Okay, there will be no queries. Then here we are ending the session for today.